Hello, everyone. In this video, I would like to address a viewer's question, and it's a good one. And the question is about why employers so often don't settle a case before getting hit with a large verdict in court by a jury. And I would like to discuss 5 key reasons as to why this happens so often, why the employers and employees who sue them, they cannot reach a settlement before they go to court, and then they receive a very surprising award from a jury for one side or the other. So, 5 reasons. The first reason is the nature itself of employment cases. Unlike other types of cases, such as injury cases, car accident cases, the liability in employment cases is almost never clear. It's almost never established. It's very easy to tell in most of the car accident cases whose fault that accident is. Hey, if it's a rear ender and I hit you, in almost every case, it is my fault because I rear ended you. In employment cases, it's almost never the case. You would usually have an employee, the plaintiff, claiming that he was treated badly or he was fired because of his age, race, disability, sexual orientation. And then you have employer saying that no, this has nothing to do with any of that. This employee was fired because he wasn't doing a good job. He couldn't get along with coworkers. He violated our policies. Maybe they received some complaints about him from his coworkers or from the employer's customers or whatever other reasons there might be. And even if some of these reasons or all of these reasons are not true, it's pretty easy for any employer to build up a story against that employee and make it look like they had a legitimate reason to terminate that employee. And whether or not it was about discrimination or it was about some other issues, or maybe it was a combination of all these factors, it's not easy to determine. And even in the end, when all the evidence is presented, it's still not that easy to tell what really happened. And sometimes you just have to take a shot at a case and try to prove it on one end, and then the employer has to try to disprove it. And because of that, both sides often have a very different idea about how they think the case will turn out. They're both confident that they're telling the truth, the other side is lying, or they don't know what they're talking about. And this alone prevents parties from settling their dispute. The second reason, and somewhat related reason, is that you have strong emotions on both sides. Many of the employment cases involve allegations of intentional harassment, intentional discrimination, or intentional failure to prevent and remedy discrimination and harassment at workplace. Who likes to be accused of being a racist or being a bigot? No one does. Moreover, even when I talk to employers who clearly engaged in unlawful retaliation, and I tell them this really looks like retaliation here in this claim that you've been served with, they're still in total denial. It's almost like a jealous lover when you tell them, why are you so jealous? Where they clearly are jealous, they're like, no, I'm not jealous. So it's really hard for employers to admit that they engaged in a discriminatory or retaliatory behavior. It just goes against our nature. You also have often a very strong and often irrational or unrealistic emotion on the other side, on the employee side, where they would say, I don't care what anyone says, I want $50 million. Or I don't care about money, I just want justice, whatever that means. Or I just want to make sure that the employer is held accountable. I just want to hurt them. I want to make this last so they suffer. Not necessarily a great way to approach a situation where you would like to reach settlement. Often these emotions change and they subside, and people change their mind and they reach an agreement, but not always. Often these emotions even get stronger and stronger as both sides invest energy, time, and money into pursuing their case against each other. This relates to the third reason that so many cases don't settle. Unreasonable expectations. They could be on one side, They could be on both sides. You would have an employer who is going to insist that they didn't do anything wrong at all, and they're not going to pay a dime, and they would rather spend $1 million on their attorneys to defend the case than pay 1 cent to the plaintiff, for all kinds of reasons, out of principle, because they cannot stand the person who sued them, and they would rather spend everything on lawyers that give them $1, or any other reason. And then you have unreasonable expectations on the employee side, where the plaintiff would say, I was wronged, my whole life was destroyed, and I want these people to pay for it no matter what. I'm not compromising, I'm not budging. Often the right type of attorney on each side will help both sides to develop the ability to approach their case more rationally and take some of the emotion out of it, but that's not always possible. It really depends on the situation, the nature of the dispute, the nature of the relationship between the parties before the dispute started, and other factors. It is easier to often settle a technical dispute over breach of contract than a dispute between an employee and the employer, where they already hated each other. They had a serious conflict before the lawsuit was even filed, and now they're out for revenge. And one way to engage in vindictive behavior is to go after each other as hard as possible. The fourth reason that cases often don't settle before trial is because it is difficult to evaluate an employment case. Okay, so you have someone who was fired. They believe they were fired because of discrimination or retaliation. They think that they're owed this much for past wage loss, future wage loss, emotional distress, and they also believe that they're entitled possibly to punitive damages because they believe that whatever the employer did, it was intentional, it was malicious, and they think they can prove it. Now, how do you evaluate emotional distress? Even if you prove that your termination was discriminatory, how much is it worth? 5,000, 50,000, 500,000? In most cases, it's a shot in the dark. It's not a science. It's more of an art putting a number on emotional distress claim. At the same time, you have employers who are saying that there is no case here. We didn't do anything illegal. We terminated this employee for legitimate reasons. But even if we have to pay, we're only willing to pay the same amount that we would pay to lawyers to continue defending this case, which is often referred to as a nuisance value. So they also have a hard time, the employers, evaluating a case, evaluating the risk of losing, admitting that there is a possibility of losing a case, and then having to pay damages, attorney's fees for both sides, and maybe some other fees. Again, the right attorney will help, whether it's the employer or the employee, the right attorney will help their client assess the potential value and the upside and the downside of pursuing a case versus settling a case, given that specific situation and that specific stage where the case is. But that's not always the case. And the clients don't always listen. Sometimes they say, thank you very much for your advice, for your counsel, but this is how I feel, and I'm paying you, and I'm going to do what I want to do, what I believe is right. In most cases, this is not a good strategy. You have to remember that one big reason you're hiring a lawyer is in order to advise you on what the right strategy is, not only to pursue that strategy. And this brings me to reason number 5. There are unethical attorneys that put more oil into the fire with their client by encouraging their clients to fight. This especially happens on the employer side. If you have a lawyer or a law firm who represents a large employer, there is an interest on the part of that law firm to make the process, to make the whole case last longer for several reasons. Number one, they want to bill their client for every hour they work because that's how it works. So the longer the case lasts, the more they can bill. And if the case goes to trial, that's where the real billing starts, with trial preparation, with entire days in court, with all kinds of other fees that the law firm can earn. Secondly, this is the opportunity for a law firm to come across as very diligent and very aggressive, even if deep inside they know that they should probably settle the case sooner than later, and it is in their client's best interest to settle rather than take the gamble and go to trial. But they have the opportunity to charge extra, to charge their client for many more hours, and at the same time appear in their eyes as very diligent and very aggressive, so that they can prove their reputation and maybe get some more work from that client, and then they win on all fronts. Now, this is not that common. I would like to believe that most lawyers don't do that, that most lawyers do advise their clients on the best strategy for their clients, not for themselves. But I also know for a fact that there are lawyers who also try to run the meter, so to speak, for all the reasons previously mentioned. So these are the 5 reasons why so many cases don't settle and they go to trial. There are probably other reasons, but these are the main ones in my opinion. And I hope you find this information useful, especially if you are an employer who is being sued by an employee. And don't forget that the practical considerations in any type of case, especially employment case, are just as important as legal theory and the laws and the regulations and the code sections that apply to the case that you have to deal with. You have your own reality, your budget, how busy you are, how consumed you are with developing your business, with dealing with maybe other claims that are going on at the same time, with your partners, with your vendors, versus what the demand is that comes to you from that employee who alleges that they were treated badly by you. You have to take all the factors into account before you make the decision on how to deal with that case, how to defend that case. And the same applies to plaintiffs, to the employees. You have to look at the practical reality. What is your case worth? And if it's only worth $5,000 or $10,000, let's just say you have a wage claim, you weren't paid for a few hours that you worked. How much money, how much effort, how much time are you going to put into that case versus potentially $1 million case? I don't have the answers for you, but these are the questions you should be asking yourself before you pursue a case or you defend the case. And that's where the right experienced employment attorney should help you make the right decision. And that right decision is not going to be a perfect decision, but it's going to be the best decision under the circumstances. Thank you.